Yes.
Okay. So I guess we are beginning the CRW special meeting. The date is Friday, February 17th, 2012. The time is 12:04 p.m. Adora, can you call the roll, please?
Yes, Commissioner Cardwell,
Yes.
Commissioner Holloway,
Present.
Commissioner Kemper,
Here.
Commissioner Sterling,
Yes.
and Commissioner Kehoe.
Present. Thank you, Adora. Dean, can you go ahead and provide some information as to why the special meeting was called?
Yes, I will. As a result of our involvement in the appeal, the injunction appeal that was filed by Commissioner Holloway and former Commissioner Mitchell, that pending litigation is ongoing, and while that appeal was in process, our lead attorney, which was Karen O'Connor with the firm of Barron Liebman, changed firms and went with the firm. She is now a partner with the firm of Stoll Reeves. Obviously, that created a conflict of interest because, as we all know, Stoll Reeves represents Beaver Creek Telephone relating to the lease issues that we have and have been under discussion for quite some time with Beaver Creek Telephone. That is, under the ethical rules, that is not an unwaivable conflict because it is related to unrelated matters. But it does require both clients to waive the conflict. It wasn't until Monday of this week that we learned that Beaver Creek Telephone was willing to waive the conflict and allow Stoll Reeves to represent CRW in this unrelated matter. And so that brought about the need for board action for CRW. And the issues with respect to the conflict of interest are really what impact does this have or could this have relating to the potential issues with Beaver Creek Telephone. One of the issues that you're always concerned about, of course, is the sharing of confidential information. That issue is typically solved and will be solved in this situation by what's called a Chinese wall, and that is that any of the lawyers and paralegals, anybody working on the Beaver Creek Telephone file will be kept out of the injunction appeal matter in the firm of Stoll Reeves, and likewise anybody working on the appeal matter will be kept out of the Beaver Creek Telephone matter. That is a procedure that is authorized under the ethical rules so that confidential information is not shared between the parties. The second aspect is that these are really two separate divisions of Stoll Reeves. It, of course, is a very large firm, but they're completely different departments. One is the real estate department, one is the employment department, so it's really unlikely that there's going to be any cross-connection between the attorneys from both divisions of Stoll Reeves. So in my view, and I sent the board, other than Commissioner Holloway, because I do believe she has an actual conflict of interest in this situation, I sent the board an email earlier this week outlining my view that I don't think that this conflict is something that would raise serious concerns for CRW. The final point is that if the Beaver Creek Telephone issue does go to litigation eventually, which obviously we hope it will not, for a number of reasons, but if it does, it is unlikely that we would have Stoll Reeves represent us. We have already engaged Miller Nash to provide some assistance in reviewing that initially, as the board is aware. So it's unlikely that we would have Stoll Reeves represent CRW with respect to that matter. So in short, it's my view that this conflict really doesn't present any risk to CRW, and I do believe that Stoll Reeves would provide the best representation with respect to this appeal.
Okay, thank you, Dean.
I have a motion.
Commissioner Kemper?
Yeah, my motion is based on the disclosures made by Clackamas River Water's legal counsel and Stoll Reeves. I move that Clackamas River Water waive the conflict of interest that exists with the law firm of Stoll Reeves, which currently represents Beaver Creek Telephone Cooperative on an unrelated real estate matter, which waiver will allow Stoll Reeves to represent Clackamas River Water with respect to the pending appeal on an injunction matter against Commissioner Holloway and former Commissioner Warren Mitchell. I further move that the board president is authorized to sign the conflict of interest waiver letter with Stoll Reeves as presented.
Second.
Okay, any discussion?
Yes. Commissioner Holloway here?
Commissioner Holloway?
Yeah, I guess you'll have to rely on our good board secretary here to tell you who has a hand up. Shall we do it that way so we know that people want to speak?
So, just go ahead and speak, Commissioner Holloway.
Okay. First of all, I think we need to set to rest what seems to be a common misconception here about conflict of interest and where the responsibility for determining that lies. A public official alone has the responsibility for avoiding a conflict of interest situation. And I find it kind of interesting that Mr. Phillips is attempting to make that determination. At least it's my understanding of the law that no. This is all part of this, and I am going to finish my statement, Commissioner. And so I think somehow that has gotten cattywampus here at CRW, and so I mean, it's not the business of anybody on the board. I didn't attempt to influence Commissioner Cardwell when he voted on South Fork Water Board. So I just wanted to make the point that this has somehow gotten totally turned around somehow in the minds, it seems to me, of most of the commissioners. And so any public and my responsibility here is, as a public official, I am charged with responsibility for protecting CRW's interests in many areas. One of them is Beaver Creek. I find it rather shocking that Mr. Phillips would even suggest, with Stoll Reeves being Beaver Creek legal counsel, that CRW would consider hiring Stoll Reeves. I understand it's very difficult to monitor that because Mr. Phillips operates unsupervised in that area, but I found that quite a shocking statement. Relative to Beaver Creek, I absolutely believe that there is an inherent conflict of interest. I worked for Coopers and Lybrand, where we had a consulting division, of which I was a manager, and we had an audit division. And I can tell you from prior experience that a Chinese wall is a myth. And I do not believe that CRW's interests relative to BCT are properly protected by having CRW represented by the same firm as BTC. And obviously the Oregon attorneys' ethics rules understand and acknowledge that those conflicts exist.
Exactly, which is why we're having this conversation, which is why they also allow a waiver if both parties consent to it. It's allowable. Is there any further discussion?
Yeah, Commissioner Kehoe, Grafton Sterling also wants to comment.
Commissioner Sterling?
The thing that concerns me, and it's demonstrated to the ratepayers and the public that are here present today, is that Mr. Phillips continues to violate his own protocol in ethical behavior. He has intentionally and willfully disregarded the very statement, and I quote from his email, "Baron Liebman attorneys have assured me," referring to Mr. Phillips, "that if CRW chooses to stay with them, they will not charge CRW for the time it takes to bring lead counsel, quote unquote, up to speed on the issues." You know, this is all about continuing to spend precious dollars that the ratepayer can very illy afford to pay for. We need to take...
We can file the appeal, Mr. Sterling. That would be Commissioner Holloway and Commissioner Mitchell. Both parties, well, at least CRW is very happy with the outcome.
Point of order.
So,
Point of order.
I will continue.
Point of order.
So this discussion is not about Mr. Phillips. It's a discussion for the board to decide if we want to.
Commissioner Kemper, Commissioner Kehoe, sorry, Commissioner Kemper, didn't mean to insult you. You, as the board chair, may certainly rule against the point of order when I have the opportunity to state it. You are not free. You are not free to ignore it.
Commissioner Holloway, you've spoken enough. So,
Commissioner Kehoe, we are supposed to be operating under Robert's Rules of Order. I am a member of this governing body. I raised a point of order. You are not free to ignore that, like it or not.
We have a motion on the table. Adora, can you call the vote, please?
Whoa, that's unbelievable. You deny me to complete my statement that I had made? You know, this is a clear demonstration, Kehoe, of you approaching November and running out of funds, anticipating that you're going to get hired on the 190 and get a good paying job. Well, I tell you, if there's anybody that needs to step down and leave, it is you, who continually take money out of the ratepayer's pocket. How dare you?
All right, we have a motion on the table, and your discussion has nothing to do with it. It sounds like character assassination with everyone except for yourself and Commissioner Holloway. So I'm keeping the discussion to the motion. So if you have nothing else to say that has to do with the motion, I'm going to call for the vote.
I'm still raising my
Tammy.
point of order,
Tammy,
Commissioner Kemper?
Grafton insisted he had not finished his statement. Why didn't you get your statement finished in the first place?
She interrupted.
Well, were you staying to the subject, though? You weren't.
Keep it to the subject at hand. If you're unable to do that, then call for the vote.
Now she's going to let you make your statement, Grafton.
That's okay. Let's just proceed. There are other methods in order to take and clarify what occurred today, and there are other actions that either the public or members of the board can take in order to protect the...
Unless there's any other further discussion that I hear from anyone that wants to discuss the matter at hand, let me know. If I don't hear from anyone saying that they do, I'm going to call for the vote.
I actually do have one question, Commissioner. This is Commissioner Holloway speaking.
Commissioner Holloway.
Commissioner Sterling referred to something that I have no information about, obviously because Mr. Phillips decided not to communicate it to me, although I am a member of the board, and that has to do with the fees. And I know Mr. Phillips doesn't give us copies of the invoices, so we don't know what Baron Liebman has been charging, but I think now that the subject has been raised in the meeting, it is certainly appropriate for discussion. What are the Baron Liebman fees that, you know, where they say they're not going to charge to get up to speed? And I do recall that there were two Baron Liebman attorneys handling this. And what are the Stoll Reeve fees?
Dean?
At this point in time, it's impossible to say what the Stoll Reeves fees are going to be.
Just so much an hour, Mr. Phillips, that's all we're looking for. How much an hour did Stoll
Do
Reeves
not
charge?
interrupt him. Let him answer
You
the
gotta
question.
be kidding me.
The, what Ms. O'Connor has informed me is that her arrangement with Stoll Reeves, which I believe I indicated in my email, Mr. Sterling, she has made an arrangement with Stoll Reeves that her same hourly rate will continue for existing clients.
And how much is that, Mr. Phillips?
I don't recall off of the top of my
Oh, you
head.
gotta be kidding me.
It's approximately $270 an hour, but I don't recall the specific hourly rate.
And what is Baron Liebman charging the ratepayers?
For, you mean on an hourly basis?
Yes,
Or-
yes, an hourly basis.
Well, it would be her rate, which would be $270 an hour, and then there was an associate that was involved in the matter for approximately $170 an hour.
So we stay with Baron Liebman and we don't have any conflict of interest, period, and things can just go forward.
That is correct.
Thank you, Kemper, or Kehoe.
I'm Kemper Kehoe today, I guess. I have a question, Cammie.
Absolutely. Commissioner Kemper?
Yeah, it's my belief that a concern here is that if we delay this longer, which it should take quite a bit longer, I would suspect, to get an associate at the previous law firm brought up to date on this. I think this is a matter where time is important because as it stands at this point, Commissioner Holloway and ex-Commissioner Mitchell still have the employee personnel records, whatever might be confidential matter on those disks that stand the chance of still being revealed. And what our real concern here is to get this stopped and get the order that the judge made enforced. Am I incorrect in that? I'm asking.
I have to say, I was very pleased with the outcome that Karen O'Connell provided to the Water District.
Absolutely.
And I also believe that if we remain with Baron Liebman, they are going to have another attorney become updated on this matter.
Mm-hmm.
And you are correct that time is of essence because there are court administrative rules in regards to filing. And correct me if I'm wrong, Dean, or perhaps Lee, that we did request an extension, but the attorney representing Commissioner Holloway and former Commissioner Mitchell, Mr. Huffman, said that that request is denied.
No, that's not. The latest information I do have is that they did give us an extension from the 21st to the 28th, which was about a week extension.
And that is the same whether or not we remain with Baron Liebman or with Stoll Reeves?
Well, it was predicated on the fact that we needed time to have the board consider the conflict of interest. They didn't put any condition on it that would apply, whether we stayed with Stoll Reeves. That wasn't part of the discussion. The discussion was simply a request for an extension.
Okay, thank you.
I don't know who's in charge of saying somebody wants to speak. This is Commissioner Holloway.
Commissioner Holloway?
Just to give Commissioner Kemper correct information, at the moment, it's my understanding that the order from Judge Bowerman continues in effect. And so there seems to be some confusion as to what is going on. I guess I will simply clarify it so that Commissioner Kemper understands.
You know what, you can speak to Commissioner Kemper after the meeting about that.
Well, she asked, Commissioner Ikeo, she asked a question, and I was attempting to give her an answer. And it would be my expectation, based on prior experience, that if I have no idea what Mr. Phillips has done in this instance, but I would assume that if Mr. Phillips made a request to Mr. Huffman or Mr. Sheehan to grant an extension because there was a new legal counsel who needed to be brought up to speed, I would certainly anticipate that that would be granted. It doesn't sound like Mr. Phillips requested anything beyond an extension so that the board could hold this vote. And I would suggest that it would have been in CRW's interest for him to have asked that question, although perhaps he considers this a slam dunk, because it sounds like staying with Baron Liebman is going to be a lot less expensive for CRW than moving to Stoll Reeves. So, I mean, that's just information in response to Commissioner Kemper's question. You'll have to ask Mr. Phillips. It doesn't appear to me that he didn't say anyway, I have no idea whether he asked for an extension to allow another attorney to get up to speed, or he simply has made this representation to, I guess, a subset of the board, because he certainly didn't make it to me until we got in here today. And I also would like to register a complaint. This document that was sent to board members came out at 10:17 this morning. When we have a 12 o'clock meeting, that certainly is not what I would consider timely notice.
Is there any further discussion?
That was a very fuzzy answer, but go ahead.
Yes, Commissioner Sterling, please.
Commissioner Sterling?
Having taken the time to become part of the public during the hearing in Clackamas County Court in front of this judge, and to have seen and listened to this Karen O'Connor, it has become, to me, evident that the reason we are here is because of Ms. O'Connor. Had she simply decided to take and follow the judicial process and understand what the defendant's attorney had in fact submitted, and then subsequently followed through by filing a judgment that is a portion of the law that needed to be done, we wouldn't be here. This discussion wouldn't be held. She'd be off doing her own thing, and the ratepayers would be saving tens of thousands of dollars. This issue needs to stay with Baron Liebman. They have the extra time if they need a little more time. I can't think for the life of me of anybody in this room not allowing them a little longer time to get whoever it is needed to be brought up. The conflict is too great. I don't care what you want to describe, Chinese wall or whatever it is. It is not something that works, period. We need to save the ratepayers' money. It needs to stay with Baron Liebman. Thank you very much.
Well, the reason we're here today is because the defendant filed an appeal, and
that is just your opinion.
I'm not done.
And you are not a legal.
I'm not done speaking. And Ms. O'Connor's opinion was the one that was signed by the judge. So if there's any disgruntledness about that on the defendant's side, that is not Ms. O'Connor's issue. Is there any further discussion?
Any public comment?
Yes, Commissioner Holloway here. Again, just to correct a misstatement, it is my understanding, and Mr. Phillips, I'm sure is equipped to tell me if my understanding is incorrect, that we're dealing now, this has nothing to do with the appeal at all. This is a motion to stay. So I'm quite confused by everyone's reference to appeal. It's my understanding, if I'm not incorrect, Mr. Phillips, that this has to do with the Baron Liebman needing to make a response to the motion for stay. Is that correct?
Well, that is the immediate issue, but there have been 2 appeals that have been filed. The appeal, and both appeals are still in the Court of Appeals. We do not have a signed order dismissing the first appeal, We do not have an order dismissing the second appeal, but the appeals are still in the Court of Appeals, so it does relate to the appeal. In the interim, your attorney has filed a motion to stay the judgment in circuit court. Yes, there will be representation with respect to that motion to stay. It involves that, but it also does involve the appeal.
But the timeline is the motion to stay, is that correct?
The timeline for the response is the motion to,
Okay.
that's the immediate timeline.
Yeah, I just wanted that corrected for the record.
Commissioner Cardwell, do you have anything to include in the conversation?
Well, the only thing that I would add is that, you know, Commissioner Sterling talks about tens of thousands of dollars potentially, or whatever number it ends up being is what it is. You can put every last penny of that money on Pat's head and Warren's head, because they're the ones who refuse to bring the tapes
Point
back.
of order, point of order, you're just taking and slandering people.
Grafton, why don't you shut up and let me finish, and you can
all
talk. And we are forced as commissioners to defend our staff's public information, not public information, their private medical information that we think may or may not be on there. If they brought the tapes back, we would not be spending one penny of this money. Every drop of it, again, is on Pat's head and is on Warren's head, and you paint yourself the victim. You're not the victim. We are the victim, because they're forcing us to spend this money. They're forcing us to spend ratepayers' money that shouldn't have to be spent. Bring the tapes back, and we can stop it at any time.
All right, do you have anything to add in regards to the motion
I do.
with Commissioner Cardwell in regards to
Oh.
their reasoning or with Phil Reeves?
I have nothing else, Kevin.
Okay, thank you.
Commissioner Kemper is trying to speak.
I have something to add, Cammie.
Okay. Commissioner Kemper?
Okay, you know, all of this brouhaha about us causing the expenditure of extra taxpayer funds, and believe it or not, there are other people here who represent the ratepayers, the taxpayers, as well as the employees, and who are concerned about all this. None of this would be necessary at all if you had not, if the two of you had not decided to appeal a win. I mean, you won. You were allowed to keep the information. You were just simply told never to use it again. You're appealing a win. That's the only thing that's causing this huge expenditure of public funds.
What's that got to do with the
Do you
motion?
have, Commissioner Kemper, do you have anything to add in regards to the motion? I'd like to move this on. I'd like to call for the vote. So if
Okay.
anyone has anything to add in regards to the motion,
No, nothing more to add.
thank you.
Commissioner Kehoe?
And I think we're ready for the vote.
Commissioner Cardwell?
Yes.
Commissioner Holloway?
No, and I'm answering in connection with my responsibilities as a
We
CRW
have qualified
duly
votes,
affected
Commissioner
commissioner
Holloway. Is it
in,
yes or no?
Commissioner Kemper, or Kehoe, be quiet and let me finish. I'm answering in my capacity as a
No,
CRW
no,
commissioner
no.
with
She's not.
responsibilities for the
Exactly.
Beaver Creek issue, and my vote is no.
Commissioner Kemper?
Yes.
Commissioner Sterling?
No,
And Commissioner Kehoe?
Yes,
Motion carries 3-2.
thank you. I move to adjourn.
Yep.
Oh, Cammie? We
We can't, you can't.
I
It's
have
been
to-
moved and seconded, and you
moved and
can't.
seconded.
Oh, it did?
Adora,
Yeah.
yes.
Okay, all right.
That's it.
I was just
Reconsider
gonna
the vote.
say that there was a public
Move to
comment.
You
reconsider
can't,
the vote.
we,
All right, bye, you guys. Thank you. I'm going to chamber event. I'll talk to you later.
you can't,
Okay, well,
you simply cannot.
well, that's okay, that's okay.
wanted to talk.
Well, you couldn't.
I understand, but you can still talk.
It doesn't matter, it's, I mean, it's too late.